Welcome everyone. We are live with another episode of Level Up Law, where every Tuesday at noon, South Carolina Legal Services levels up your legal knowledge about an area of law that we practice in. I'm attorney Susan Ingalls here with our producer Kenneth Elliott of our IT department. We're in the background, and you are viewing attorney Cheryl Wright in our Charleston office. Earlier this year, Cheryl did a two-part series on solar energy, including what it's all about and what to watch out for as far as scams and fraud involving solar panels and other renewable energy. Today, Cheryl is going to update you to introduce the new solar consumer protection regulations that went into effect in May here in South Carolina. But before we get started, I did want to let our audience know that South Carolina Department of Consumer Affairs has a webinar today at 2 o'clock that will go into more detail about the new regulations, and Cheryl will be giving you some of the details about that and how to sign up for it. And then also just want to let you know, as a reminder, this is not legal advice. It's just general information for the public. If you need the help of a lawyer, you can always call our intake line here at South Carolina Legal Services or apply online. That information for doing that will be provided at the end of today's presentation. And just so you know, not to worry about furiously taking notes during the webcast, to remember all the great information that Cheryl's going to give us. All of our episodes of Level Up Law are posted to the playlist on our YouTube channel entitled, Level Up Law, of course. And usually Kenneth does that within about 24 hours. Now, we don't anticipate having time for questions today, so the audience will be in listen-only mode. However, if you do have questions, you should definitely sign up for that webinar with Consumer Affairs this afternoon. We will post a recording of today's episode, as I said, on our YouTube channel, and we'll link it to Cheryl's previous solar energy series, as well as any recording of the Consumer Affairs webinar. As always, be sure to check out our social media, YouTube and Instagram, Facebook, Twitter, and LinkedIn as well, and get all the up-to-date information that we provide on Level Up Law and our other resources. Those websites and social media handles will be provided also at the end of today's presentation. So having said all of that, to introduce Cheryl Wright, attorney in our Charleston office. Cheryl, take it away.
Thank you, Susie. So today we'll be talking about the new South Carolina regulation on the marketing and sale of renewable energy, including solar, and we'll be discussing the protections for South Carolina consumers. As Susie mentioned, there is going to be some informational sessions today. We have the website consumer.sc.gov, upcoming presentations and webinars. It'll be today at 2 p.m. The South Carolina Department of Consumer Affairs presents the solar regulations, requirements, documents, overviews. So that'll be a great informational session. Like she said, if you have any questions after this presentation, please check out that session as well. So our previous Level Up Law presentations, they were a two-part series. First, we discussed a quick guide to solar panels in South Carolina, and then we also discussed solar energy frauds and scams. But today we'll be discussing the new regulations. So where did the new regulation come from? The South Carolina Energy Freedom Act, which became in effect May 16th of 2019, it directed that the South Carolina Office of Regulatory Staff, also known as the ORS, to develop consumer protection regulations for the leasing of renewable energy generation facilities. Also, the South Carolina Department of Consumer Affairs develops consumer protection regulations for the sale of renewable energy generation facilities. So on May 28, 2020, new solar consumer protection regulations went into effect and were published in the state register. So we're going to be focusing on section 5827-2660, the development of consumer protection regulations. And like I said, the Office of Regulatory Staff in the Department of Consumer Affairs, they were directed to develop consumer protection regulations. So the purpose of this was also providing protections to fulfill the duties and responsibilities provided for in the sections covered under the Office of Regulatory Staff. They'll develop a formal complaint process as part of the consumer protection regulations. Also, this will allow them to conduct investigations into alleged violations, issue cease and desist orders against further violations, impose an administrative fine not to exceed $2,500 per violation on a solar company that materially fails to comply with the consumer protection requirements, and voiding the agreement if necessary to remedy the violations or the violation. So we're going to go over some important definitions for you to be mindful of. If you are leasing solar energy as a homeowner, you are a customer-generated lessee. So that means a lessee of a renewable electric generation facility. So it generates electricity from a renewable energy resource. It has an electrical generation system. It's located on a premises or residence owned, operated, leased, or otherwise controlled by the customer generator lessee. That is also the premises or residence served by the renewable electric generational facility. It's intended only to offset part or all of the customer generated lessee own retail electrical energy requirements, and it meets all applicable safety, performance, interconnection, and reliability standards as established by the Commission. You have to be mindful because there are some differences, especially when it comes to co-ops and things of that nature. There is a different complaint process that they have to go through. But most electrical providers are retail electric providers. So an electric utility as defined in section 5827.10.7, it includes municipalities to the extent of their business, property, rates, transactions, and operations without the corporate limits of the municipality, persons, corporations, their lessees, assignees, trustees, receivers, or other successors in interest owning or operating the state equipment or facilities for generating, transmitting, delivering, or furnishing electricity for street, railway, or other public uses, or for the production of light, heat, power, or for the public for consumption, but it shall not include an electric cooperative or a consolidated political subdivision. So like I mentioned earlier, there are some differences when you're dealing with electric cooperatives. So now we are with the who, what, when, where, how, and why. So the Office of Regulatory Staff and Department of Consumer Affairs are directed to develop consumer protection regulations regarding the sale or lease of renewable energy facilities. These regulations shall provide for the appropriate disclosure provided by sellers and lessors. Sellers must comply with Title 37 of the South Carolina Consumer Protection Code. Nothing alters those existing protections. To fulfill the duties and responsibilities provided for in this section, the Office of Regulatory Staff shall develop a formal complaint process as part of the Consumer Protection Regulations. The Office of Regulatory Staff is authorized to enforce any applicable consumer protection provisions set forth in this title by 1, conducting an investigation into the alleged violation, 2, issuing a cease and desist order against a further violation, 3, imposing an administrative fine, and 4, voiding the agreement if necessary. So who? The South Carolina Department of Consumer Affairs, they develop consumer protections for the sale of renewable energy generation facilities. ORS, the Office of Regulatory Staff, they develop the protections regulations for the leasing of renewable energy. So you have to be mindful. One is for the sale of renewable energy, and that's the South Carolina Department of Consumer Affairs, and ORS is for the leasing of renewable energy. So please keep that in mind in determining which applies to you and what complaint process do you have to go through. So what? The consumer protection regulations regarding the sale or lease of renewable energy generation facilities pursuant to the Distributed Energy Resource Program found in Chapter 40. Enforcement of these protection regulations and the rules are intended to define good practice. They are intended to ensure adequate and reasonable consumer protection. So they're intended to look out for the consumer, and you would be the consumer in this case. When? So a brief summary of important effective dates. Effective now. So these are in effect now. The waiting period. A written copy of the contract must be given to consumer aged 70 or older at least 3 days prior to signing. So a written copy must be produced for consumers 70 and older 3 days prior to or before the signing. This waiting period allows the consumer to review the contract without pressure and to shop around if necessary to see if that best fits their needs. So that gives you a window of 3 days prior to signing to shop around and make sure that the product is what you are in need of. So just make sure you take your 3 days and make sure you do use that time to do your research. Also, you have a right to cancel. All consumers may cancel a contract without fees or penalties within 10 days of signing it. When a building permit is denied or a consumer's homeowner association does not approve the install, a consumer also has 7 days to cancel the contract or amend it. So that's something you need to be mindful of, especially when you're in a subdivision that has an HOA. So that's a 7-day window which you have to cancel your contract. But also you have a 10-day window that you may cancel a contract without fees or penalties. And also a copy of the contract. So the consumer must be given a copy of the contract that contains a description of the fees, your install date, your details on savings as described, your warranty information, and more details as required by law. So these 3 things, you have to have a waiting period, you have a right to cancel, and you're entitled to a copy of your contract. So the next 2 things, they go into effect August 28th. Consumer education. Sellers must give consumers a pamphlet detailing their rights and responsibilities related to the sale of solar. So make sure you tune in at 2 o'clock on the 24th, which is today, and that will give you a brief rundown of what that pamphlet is and how you go through that process and what you should look for, and also your recourse if you have any complaints. And standard disclosures. Contracts must include a standard disclosure to help consumers understand the most important terms of the contracts and also the company's different offers. So make sure that you have that in your contract so that you understand what you're getting into. So these are things that your contract must include. So where? The jurisdiction. The rules contained in the regulation apply to any person, any firm, any partnership, any association, any establishment, or any corporation, except any other exempt by South Carolina statutes, which is now or may hereafter become engaged as a lesser of renewable energy facility within the state of South Carolina. So it applies to anyone unless they're exempt. Any person, firm, partnership, association, establishment, or corporation, except those that are exempt, which may now or may hereafter become engaged as a seller of renewable energy within the state of South Carolina. So both the lesser and the seller. So how is it enforced? These regulations help to protect consumers by requiring appropriate disclosures and by creating a formal process to resolve complaints, which we did not have before. The regulations also formalize the complaint process to assist consumers with disputes arising from lease agreements. So these are from the lease agreement. If the consumer is not satisfied with the leasing company's actions to remedy the complaint, the consumer may request an investigation by the ORS, so the Office of Regulatory Staff. This complaint process includes an investigation of alleged violations, notice of violations, response to that notice. So they're going to give notice of the violation to the company and allow them to respond. They're going to make a decision as to what is going to occur with the violations and how they'll be remedied. You'll have a request for review of the decision if you feel the need to request that review. And if you need to appeal, there'll be an appeal of agency decision. And for the complaints about the sale of solar energy, those will still go through the South Carolina Department of Consumer Affairs. So like I mentioned earlier, there's a difference between the leasing and the sale. The leasing is going to go to the ORS, and the sale is for the Department of Consumer Affairs. So why did this happen? The law addresses common trends gleaned from the nearly 200 solar complaints received by the South Carolina Department of Consumer Affairs from 2014 through 2020. The regulations requirements are aimed at combating bad business practices and helping consumers make an informed decision. So they are looking out for the consumers so you can make more informed decisions, and also making sure that the companies are promoting good business practices and not bad business practices. So we have some reminders from our previous presentations, some reminders on how to find a reputable company in South Carolina. The North American Board of Certified Energy Practitioners, they maintain a certified list of system installers. And the South Carolina Solar Council and the South Carolina Solar Business Alliance also maintains a list of member installers. So these 3 websites will help you find good resources of certified installers for your solar panel systems. And we also provided you some websites for your resources. Like I mentioned, the ORS website and the Consumer Affairs website. So the ORS is for the leasing, the consumer is for the sale. And now we have South Carolina Legal Services contact information provided for you for your review, and we have resources for general information for the public. So just be mindful of these websites. We provide our different social media handles here. We have a legal aid telephone intake services if you would like to apply for our services. The number is 1-888-346-5592. And they're standing by Monday through Thursday from 9 a.m. to 6 p.m. Or you can apply online at www.lawhelp.org/sc/online-intake. Susie, back to you if you have any comments.
Okay, thanks, Cheryl. That's awesome. That's a lot of big words in that new regulation, so thanks for breaking it down a little bit for us. Really appreciate that. A great follow-up to the two-part series you did back at the beginning of the year, so thanks for an excellent presentation. And as you mentioned, all our information is here on the screen, and I would add that if you want to apply online, we actually have a Level Up Law episode with some tips about that online application. And that's really a great way to apply for our services because you can do it 24/7. And, sometimes we may have to give you a call back and get, some additional details that maybe aren't evident in your online intake, but that's just a great way to do it because not everybody can do that in person or on the telephone application Monday through Thursday from 9 to 6. So if that's difficult for you or you have a little bit of difficulty getting through, the online application is a great way to go. So yeah, thanks for mentioning all these connections for how to follow legal services, how to apply for our services, and also how to access all of our many educational resources, Level Up Law episodes, other videos we have, our online classrooms, and just a lot of other materials and resources that we provide to the public on a really wide range of topics, and it's a really broad range of different kinds of resources. Hopefully there's something for everybody. So now to our audience, thanks for tuning in, and if you found this helpful, and if you know someone that it might be helpful to as well, definitely go to our YouTube channel tomorrow at SC Legal Services and share the broadcast. We want as many people as possible to get this important information and know about this subject that Cheryl's been talking about. And of course, while you're there, we would love it if you would like the presentation and hit that subscribe button so you can get notifications when we post other resources on our YouTube channel. And if you hit the little bell and sign up for the notifications while you're there, you'll get that notification every time that we do post something on our YouTube channel, which we do at least once a week, but a lot of other times during the year as well. And also be sure to tune in next week when Stephanie Vanderhorst, that'll be Tuesday at noon next week. Stephanie Vanderhorst, also of our Charleston office, one of our great attorneys who's our employment law unit head, she will be talking about unemployment benefits during COVID, and particularly how to deal with overpayments. So that will be a real interesting episode as well. So we invite everyone to tune in for that episode and all the ones in the future every Tuesday at noon. So let me again thank you, Cheryl, for the great presentation, and I want to thank everyone else for tuning in today on Level Up Law. That concludes today's webinar. Thanks, everybody.